What's up, guys? On today's episode, we have Stephanie Cox. This is a phenomenal conversation. She is a family law attorney with Sorbera Law right here in Guelph. And her and I are having a great discussion about divorce, separation, and everything that ties in with that. Custody, real estate, support. And I think that you guys out there, if you did have any questions in this realm, this video definitely answers it for you. Now, of course, Stephanie has had a great career, and you'll see that as soon as you jump in here. But she was a human rights and civil litigation attorney prior to joining Sorbera Law, where she was practicing in the Superior Court and the Ontario Court of Justice, and she was advocating for marginalized groups and human rights abuses. So she has tons of experience. Now, just from listening to her, I know, one, you can trust her, but on the flip side, you know, she is fierce and I wouldn't want to go up against her. So I can see the compassion, okay, but I can also see how well-rounded she is as an attorney, and you're going to absolutely love it and it'll blow you away. So guys, without further ado, we have Stephanie Cox. Hey Stephanie, thanks for joining us today. I've been tracking you down now for a while, it seems, and I'm glad you finally decided to come on the show. I'm looking forward to this. I think you're going to give some great perspectives to people out there that are in tough situations, and I'm just ready to go. I'm locked and loaded. I have got 18 total questions for you.
Well, I'm really happy to be here, and I think that this is a great forum to have a discussion around issues that are really pressing and often on people's minds, but going to a lawyer's office, knowing where to begin is really daunting. So hopefully this podcast can demystify some myths and also perhaps the scary burden of what it may look like to start the process of getting legal advice if you need it.
Yeah, because lawyers are scary, right? Are you nervous?
I'm a little nervous, but I'm okay. We
got like 3 different cameras on you.
I think what it is that, you know, you always have the Law Society hovering over you. So I do want to be super, casual about this and informative, but I do always have to make the caveat that whatever we're discussing today is legal information and not legal advice. And so if anyone wants personalized legal advice, they need to contact a lawyer and get that individually. Kyle, we need a disclaimer, okay? Like right down here, you know? None of this advice is legal or expert advice. I've seen that in the contracts a couple times. Okay, so before we jump into the family law, I just wanted to kind of backtrack a little bit. So where were you born and raised? I was actually born and raised in St. George, Ontario, small town just outside of Brantford, in between Cambridge.
Big hockey town, no?
Big hockey town. You know, I went to high school in Brantford, you know, where the Gretzkys are from. Big hockey town. And I loved where I grew up. You know, it sounds a little, I don't know, cliche or over exaggerated, but I did have a childhood of, you know, there's a park next door, you take care, you just run amok all night and are with your friends, and you're neighborly, you know, shovel someone else's driveway on their behalf, or you know, cut their lawn. You know, when I
smaller though.
When I watched Schitt's Creek, I think you know the show Schitt's Creek. I think, and this was my upbringing at times. But I was very lucky enough to have 2 parents who wanted to expand my world, and so I've done a lot of travel. No, they're not. They're not. My parents were teachers. And so I think it was interesting how I entered the world of law and entered law school with a lot of people who did have lawyers in their family and understood a bit more the culture of law traditionally and what that process looks like. But I did not know that, so I didn't have any sort of advantage that way. But I don't think it's been any disadvantage in any way.
Sometimes it's actually better because you're not stuck in the same sequences, right? Like you can see things a little bit differently. You know?
I would say I've had. I think it's beneficial for most people to have a wide range of life experience. Right? It helps you. perhaps be less judgmental, understanding that there's different perspectives, there's different ways of doing things, challenging yourself. Yeah.
Well, teachers have a way of doing that too, though, right? Like, so then was it like, let me guess, your parents were like, you've got to go into law, you're going to be a lawyer, and then every day growing up, you're like, I'm going to be a lawyer?
I don't think so, but they definitely, I always got you talk too much in class.
Yeah.
You've got an opinion.
Attitude problems.
Not necessarily attitude,
be honest. We're here to be honest.
No, I don't think so. But I do, from like grade 1, the report card was, she's talking in class or she has opinions. And even when I was in undergrad and we were in small group, I took political science and the same kind of comments were made. So I actually didn't know that I always wanted to be a lawyer. This was not something that I grew up thinking would be the case.
Okay.
Having said that, I can see that throughout my whole life, I've been very confident in wanting to advocate for others or to be part of a solution or to see what I see as an injustice or an inequity and be part of the process of trying to cure it. So I think that's been a steady theme throughout my life, and both my parents definitely fostered that.
So where'd you do your undergrad?
At Western.
At Western. And then law school?
In Windsor.
In Windsor. Yeah. Okay. And then from there, you went right into the nonprofit.
Yes. Yeah.
Right. Okay. Then that kind of nonprofit shows you got a bit of a heart too, right?
Yeah.
Because that's not something people just do. Like.
Yeah, it's very emotionally taxing. There's nothing glamorous about it.
You go home and you cry into your pillow, or
it's tough.
Glass of wine.
Yeah, it can be tough. Even in family law, there's times where you really carry. I mean, I care about every case, but especially in circumstances where you can tell that a child is being harmed or that there's intimate partner violence, and you do feel the weightiness of wanting to make sure that you're doing the right thing and that you've argued as best as you can and that you've helped someone navigate that process responsibly.
Yeah, it's a fine line, like being able to shut something off. Like I always find in our industry, like I've got to deal with one issue, a deal not closing, and everybody's upset and worried about litigation. And then I've got to jump right into a listing presentation and be like, hey, how you doing?
Yeah.
And I can do that. I can and even if something's going on at home, I can easily like my wife always bugs me about it, right? Like she's like, you can just share it. Like, so like if she gets angry, her emotions like the whole day, like you can see it, right? Whereas me, I'm like, hey.
Yeah.
So it's like it's a learned skill. I know that, but it's not easy sometimes, right?
It's true. I would say, just like doctors, though, you're no good to someone, especially as a lawyer, if you're so invested in the case that you're so clouded that your emotions are getting the best of you and you can't objectively analyze the situation. So as much as I'm glad, I have empathy, I'm a critical thinker, I can see the
future,
the things that may be happening that bother my client and myself, but you do have to take a step back to be able to be that strong advocate for someone. And your brain does have to be able to switch between this case and moving to another case. So I don't think, a lot of my peers, you all go to law school. You're all getting generally the same education, but it takes a certain disposition, a certain personality to want to do litigation specifically, because you are constantly shifting, moving. You have to be able to adjust constantly and just kind of roll with it. So
one of the things that I always tell my team members here is never let your ego ruin a deal, right? Like, because you do get, and you'll get opposing counsel, I'll get opposing realtors, and sometimes, someone's real sharp or real catty or and then I have to kind of like backtrack it. And a lot of the times I'm like, we don't need to do that in order to get a deal here. We don't need to treat each other like that. So like, let's just kind of start over. And I'm doing that a lot. And these are like these are like wins that are like, nobody else knows about them but me. So sometimes I'll like go home and I'll be like, I did that.
And as you should, because sometimes these jobs require a lot of resilience.
Yeah.
You're not always going to get the thank you. You're not going
No.
to get the validation. So I think having that kind of practice of self-recognition of, hey, I grew here.
Yeah.
I'm glad I did that. And was the bigger person, because
Yeah.
it's not always easy.
So like, and as well with our clients too, like some clients are kind of like, yeah, well, you get paid, so deal
Right.
with it. And then I have other clients, like we had one last year, they took the whole team out for dinner. They were so happy. So I'm like,
That's nice.
it was nice, right?
Yeah.
Okay. So now we're going to really dive into why we're really here. Okay.
Mm-hmm.
And I do feel like it's a great topic. It's a topic that not a lot of people talk about.
Mm-hmm.
And I'm really interested. I've got these questions. Okay. I'm really going to put you on the spot. Okay. But I think that there's a lot of people out there that might be interested in all this stuff, because I
Yeah.
do think that the more I sell real estate, the more I see people splitting, and sometimes they won't tell me they're
Right.
separating, but I'm just like I just know. I'm just like, okay, there's like just little key tells, right? Closet closed, one toothbrush versus two toothbrushes, stuff like that. So let's go right in here. So have you witnessed a lot of separations since COVID? Has that had an impact on your business?
It definitely has. During uncertain economic times, there is a correlation between that and a spike in people separating. And I would say, looking at the social science research on this, it is common that when people are at risk of losing their job, are housing insecure, and are under those kind of stressors, those are major stresses for anyone's relationship, right? And the roles and contributions, and the balance, right? And so that those circumstances, in addition to not knowing what's going on in the world in such a crazy time, the isolation, suddenly not having space from one another if you're not going to work, right? You're all in the same house. I mean, it's a pressure cooker situation. So there were a lot of separations during COVID. And then even till this day, the issue of, at least for children, deciding whether they should have a vaccine, COVID vaccine or not, has been a really pressing issue for parents, and that's an issue that's been before the courts often. Even during COVID, there was the concern around, especially because the government had talked about, mobility and only remaining within your 5 or whatever. There was different levels of what you could or could not do for socializing. And so that really had an impact on, and rightfully so, one parent, who is a nurse, is saying, I want parenting time with my child if you're co-parenting because you're separated. And the other parent rightfully has fear that, well, you're working in a hospital. And I'm scared you're going to expose our kids to COVID or what have you. So that was really, just like anything that's happening socially, right? People go to the courts to say, how do we resolve this? And that was certainly a novel circumstance of, what are we reconciling here? And ultimately, for the most part, at least with parenting time, courts said, being able to see your children and have that bond, taking certain measures.
Didn't matter what the profession was.
Didn't matter what the profession was, is far more important, right? Again, balancing, two things. It's not ideal, right?
So it wasn't, you're right. So like, you've got, isolation, you're cooped up together, you've got maybe financial issues because people weren't working the same. Like we were going like crazy. I'm sure you guys were too. And then you're right. Like if you had disputes over the vaccine, then, because we did see that, like we saw, like it would like ruin families almost, right? And if I went to a house for an evaluation, you could see like both sides would be separated, or one side would take one stance, I'd go to the next house, and then they'd take the next stance, right? And for me, I didn't really care, right? I'm there to sell real estate, right? So like, here we go. But that's a good point to bring up. So I guess like economics would probably be one of the number one stressors. Okay. Maybe not the sole thing, but one. Okay. So that's interesting. So if anybody's out there and they're wondering, if their relationship's having issues, right? If it's not economic stress, then, they're probably doomed, right?
I don't know, but I think we were talking about this earlier. You know, most people take what I understand about 3 years to decide if they're really ending something, if it's been a long-term marriage or a long-term common law situation, particularly if you have children involved, right? Because it is going to shift. Even if you're an incredible parent and you meet your children's needs, you make decisions in their best interest, you've always been, you know, an equal partner, or even if it's, hey, mom drives them to school but dad picks them up, or whatever it may be, it is a huge and difficult shift. Because even if you are going to have 50-50 parenting where child's with mom or dad 1 week, or I don't want to be heteronormative, dad and dad 1 week, right, and the other dad, you suddenly don't see your kid every day. Right? And so it really is a big shift for people. And I'm not saying at all that that is the only reason, or to stay in an unhappy marriage or an abusive marriage. I'm not here to give that kind of advice. But it does take people a long time to really come to that point of, okay, this is final, apparently, right? That's what research says, that it can take people years to come to that point. And human relationships are difficult, right?
I would say that,
it
though.
takes
like
work.
Most relationship, like if it is going to end, it's a process. It's not like,
process.
Here you go, I'm done.
Yeah,
right?
and so to give you the lawyerly answer, you know, separation, whether you're in a common law relationship or you're married, the law says separation is the date when there's no possibility of reconciliation. And I think that's term reconciliation is really important because it recognizes that people have probably taken a cooling off period and come back together and tried it again, right?
Yeah, I've seen it.
You know, and I've seen it in law too. And so what that means, and here's some information, is that what I say to people who've called me and said, I'm thinking about doing this, right? But I don't know what this looks like. What am I up against? What does this process look like? I will say to them, you know, if this is your final straw and you've made this decision that you're leaving the relationship or you want to separate, make it very clear. And I know it sounds cold-hearted, but
send them an email.
Send them an email, maybe text, confirming the conversation you had, because to get a divorce, at least, your divorce will not be issued any earlier than 1 year from the anniversary of your date of separation. And people do not want to be in court arguing with a judge around what their date of separation is.
But you probably get that, right? Like if they take a break without sending that email or text, and then they could just say, well, you left the house at so-and-so, so here you go. They stamped it. And they say, well, no, we were on a break. We still anticipated getting that together. Then 3. But I mean, the margins are probably only a few months,
It
right?
can be.
It's not going to be.
Yeah, and it can be. Now, it's not as if both parties have to decide they're separating. So let's say in the scenario that you just gave, that one person left, and in that person's mind, they're thinking, this is just a cool off period. I don't know what I'm thinking, in fact. I haven't decided yet. I just need a break. But then the other person who's been left may think, you know what? I'm done.
Yeah.
And so until there's a conversation, which technically that's all that really needs to take place. I'm just saying in evidence if it's going to be disputed, right? Then it is better if this is something that you've been having a conversation with your partner about, and you've gone to therapy. Some people are thinking, okay, we're still in couples therapy. There's no way we're going to be separated or what have you, right? So yeah, it's a journey. It's a journey. So it is important to know what day is that day where you're saying, this is it, we're not reconciling. Now, once in a while, that's been said, people don't take steps to separate their assets or create a separation agreement, go to a lawyer, or really takes the steps to establish separation. And then a year later, they say, no, we're separating now. And so that's when, you know, lawyers have to get involved and say, what is the date of separation? Was it that date, but really it's what, if you've reconciled, then it's the date past reconciliation. And this is important, not just for...
They've agreed too. Like if they both mutually agree, then it's a non-issue.
Then it's a non-issue.
But it's clear it's something that has to set the precedent for the timeline on if they're going to get a divorce.
Yeah, it sets the precedent for the timeline, and it affects the your equalization of your assets, which is the concept that you're going to share the net wealth growth that you have made throughout your marriage. So that is from what assets did you own at your date of marriage and your date of separation. And this only applies to married couples. And so the law says that you look at what the net wealth is throughout the marriage, and then the spouse with the greatest wealth pays half the difference to their other spouse, to their spouse. So, for example, if throughout the marriage, spouse A has a total net worth of $100,000 and spouse B has a total net worth of $50,000, the difference between that is $50,000. Half the difference is $25,000. And so the person who has a net wealth of $100,000 pays that $25,000. And that is recognizing that inherently a marriage is a joint family venture, that sacrifices has been made to accumulate that wealth. And so that's your division of assets. And sometimes people confuse division of assets with, suddenly the car that was in my name is now your name. Really what it is looking at what is the value of your wealth, taking into consideration your liquid assets, your real assets, and then you're required by law to share in that. Now, if you did a separation agreement and you didn't go to court, you would have the opportunity to negotiate that, and certainly you would have to then sign away a waiver that you've consented to not avail yourself to really what you're entitled to. But all to say, that's another reason why the date of separation, the date where you say there's no reasonable prospect of reconciliation, is important, because the court is looking at what was in your bank account that day. And so sometimes people will say, I want my date of separation to be a month prior because there was $50,000 more in the bank account that day, and therefore more assets to divide between the two of us. Yeah.
Right? So
but there's special rules with respect to inheritance.
Okay, because I could go all, this is super exciting for me. So, all right. So I guess one question I have just before I jump into this is, if you're at a party, can you tell whether the couple's going to get separated? I cannot. Do you have the goggles? Can you do that? Your friends come to you and okay, here we are, let's have a dinner, and then at the end of the dinner, they're like, Stephanie, what do you think?
I mean, I think that
do you have, here.
I think I
have you predicted it before?
Yeah, I mean, I think just by the nature of who I am as a person, I definitely can be a hopeless romantic, but I can be very logical.
Yeah.
And I think that what I've always learned is the things that are small, that are indicative of a bigger issue that seems small at that time, are going to be magnified when you're married and you're managing a household. And so if you're not communicating now, if someone's not helping you right now without kids or with kids, doing the laundry and taking part in sharing the load of what it is to parent, then you take notice of those things. And I think that could fracture a relationship in the future. And then, I think now that I am so well versed and specialized in family law, it is a unique position to be in. I have the opportunity to know the law and understand it, but being in this position, I am always shocked what people don't know when they get married. Yeah. Right? They, some people who are religious will take a course through the Catholic Church, or that's a requirement.
That's tough in itself too, right?
Right? But that's different. And so I'm really a strong advocate for a marriage contract or a prenuptial agreement, because
I'm asking the questions here, so you can't go ahead.
But they're related, right? It's like, I am always surprised that people don't realize that this is a financial contract. So if I see my friends unable to figure out very small things or not take part in decision making together, or one person being super dismissive, or I don't know, you can just sort of see that this is going to be an issue in the future, and this is going to be really hard to untangle if and when you separate. Like, some people, my one friend, and I'm sorry to bring this up, but a couple of friends of mine.
Tell us her first and last name.
No, they would kill me. Have joked saying, like, they just never stop partying or coming home late, or I don't know what's going on. And they've been married 8 years and they've got a young child, and they're like, was I duped? And I'm like,
maybe.
I don't think so.
Yeah.
Have you noticed that, their tie was on their head, having fun at the wedding, like they were the wildest person in the room? And by no means am I saying just because you're gregarious and outgoing that you're going to be irresponsible. Yeah. But sometimes I'm like, that person's fun, for sure. Don't get me wrong, life of the party. But they haven't changed with the call of duty that's required of them when they've had children, whatever. They're still living in that party zone. And it's kind of like, I don't think you were duped. Like, people show you who they are. It's just, are you paying attention?
Are you gonna watch it? And I almost see it like I almost see this could be like a Seinfeld episode where, like, they tell you a story and you're like, oh. And then they're talking about it later, like, did she say oh, or did she say oh?
That's such a Seinfeld. That's a good reference.
Okay, well, that's interesting. So let me tell you this. So what's the difference between a separation and a divorce? Or is there a difference, or is it just the process?
There's a big difference.
Okay.
So your separation is in common law, without any documentation, without a judge saying so. If you have declared to your spouse that you're separated and you've been separated for 3 months, you're separated.
Okay.
You would be able to declare in your income taxes that you're separated because it's been 90 days.
And just one party can do that?
Yes. It's not required in law that both people agree to this.
Okay.
And so a separation really is looking at how are we separating our assets, how are we paying spousal support, child support, if you have a child, a parenting plan. So your separation is, you've separated. You're no longer in a relationship, okay? But a divorce, and then part of either resolving your divorce or your separation is looking at how you're dividing up, like I said, your assets, whether there's support being paid. Those are considered corollary relief. A divorce is literally the ending of your marriage issued by a judge. So some people can have a separation agreement that determines how they're going to resolve all those other issues, such as property, child support, spousal support, what have you. But to be legally divorced, you have to get a divorce order and certificate
you need
from
the separation
judge.
Agreement.
No.
So you don't need the separation agreement to get divorced, right?
Well, what you would need, so for example, yes, you could absolutely apply for a divorce, but when you apply for a divorce, particularly where there's children involved, you have to swear an affidavit that speaks to these things, and a judge is not going to issue a divorce to you if they can see that there's been no agreement reconciling like the parenting plan for your child. So oftentimes people will do this. I negotiate separation agreements, which include, a parenting plan all the time. And then at the end, people will say, okay, now I'm just going to file for divorce. So what you do is you fill out very simple paperwork, you serve the other side, you complete an affidavit. Often I'll attach the separation agreement to the document requesting divorce. And then you submit that to court, and you're not called into a court. A judge reads this and issues the divorce without requiring parties to attend. Do you need both signatures, or can someone say, I'm not going to get a divorce? Yes, so you can contest a divorce. So in situations where there's a separation agreement, oftentimes because you've agreed to resolve everything, there's usually a clause that says this person's going to pursue the divorce, like file the affidavit,
Yeah.
and it's going to proceed uncontested. If a divorce is uncontested, you generally are not in the situation where you've been able to negotiate everything else but for that, because that just simply wouldn't make sense, right? So where there's no separation agreement, people will file an application for divorce with the court, and in that application ask for resolve as it relates to property, child support, and spousal support, all those other issues that you weren't able to resolve in a separation agreement. So for people who do a separation agreement, they do that agreement. That is a contract between the two of them. And they don't have to file it in court. They simply, if they want a divorce, they file for divorce. The other doesn't contest it. If someone did, I've never seen this, but let's say someone did, it would be very confusing because you've already agreed to terms of separation. But not everyone can resolve their separation that way. And so then it's just this one process of filing for divorce along with your claims to property and support and everything else.
So you could file for the divorce without the separation agreement. Like in essence, could you file for divorce and deal with, real property, spousal support, custody, all in that procedure?
Absolutely. So there's two different processes for divorce. There could be it's just different forms. I won't get into the nitty gritty, but in essence, if you're unable to resolve those other issues following your separation, those issues will be issues before a judge while the judge is also issuing your divorce.
And then, I guess the difference between so if you can't come to a separation, right, and you go through mediation, then you go to trial, right? Trial.
Court. So you would file in court.
But that's not the same thing as just filing a divorce paperwork.
That's correct. Yeah. So if you've already negotiated your terms of separation and there's a contract, right? It's a separation agreement, then you just file a very simple paperwork with the court asking for a divorce.
Yeah.
You don't have to go into court. If you're unable to resolve all those issues, then in your application for divorce, you also ask a judge to resolve those other issues, and that results in you having to adhere to certain timelines, to go to what's called a case conference, to go to a settlement conference, and then if you don't settle those issues along the way, then you're forced to go to a trial. But divorce is very separate from, a divorce is you're not married. A divorce isn't necessarily a divorce is you're not married anymore.
So the benefit too, like a separation agreement is something, if someone's thinking about separating and they've made up their mind, they've had their date, October 1st, whatever it was, your advice would be obviously to call you, okay, but start the process for an agreement, separation agreement. Now, if they do go to court, okay, it might not necessarily be in their favor either, right? So sometimes the separation agreement might be quicker.
Yes.
It might be more beneficial for one party versus the other party. But if a judge has to decide, the judge is going to decide based on some strict criteria.
That's correct, yeah.
Okay, cool.
So having said that, though, a separation agreement does need to be consistent with what the law says. There has to be an agreement that is not so beneficial to one party that the outcome to the other is unconscionable. Right? And so there's a balancing act. A separation agreement definitely gives parties more certainty, more creativity around their outcome. Yeah. For example, if you want to buy your spouse out and you go to court and say, Judge,
out of a house,
I want to keep the house and I want you to order that I'll just pay my other spouse, her share of the house and what she's entitled to.
When I'm ready.
A judge doesn't have the authority to do that.
Really?
A judge can order the sale of the home, or under the Partitions Act, or even outside of the Partitions Act. But there's many good reasons why you would pursue a separation agreement. Oftentimes it's faster. Oftentimes it's therefore less costly. And like I said, you have a bit more certainty. You can control the outcome a little bit more. Having said that, though, if you're emailing someone who never wants to respond or doesn't want to come to the table and compromise a bit, then you're just paying your lawyer to send all these letters and to get nowhere. So I do think the conversation around a separation agreement with my clients does take into account, considerations of, is this person abusive? Have they been abusive throughout, such that this wouldn't be a proper way to negotiate, or they may be unwilling to negotiate, right? Or sometimes it's just a game of psychology, right? Like some of my clients have said, that person hasn't done their taxes. There's no way they're ever going to fill out the financial disclosure form that's required of them for a separation agreement. Or, you say, okay, let's exchange our financial disclosure in the next 2 months, and they get it to you 6 months from now and continue to, be that slow in the process. In that situation, I'd say, let's just go to court, because at least in court, there's timelines that say in 30 days you have to do this, and you keep the pressure on. And I do want to mention that most, like 90, almost 95% of people who avail themselves to the court process are still settling in court or outside of court and not having to proceed to a trial. So
would you say about 5% of the people go to court?
No, I don't know the number of people who go to court, but I'm saying that it's a small amount of people who are required to go to trial.
But it wouldn't be 50%. It might be like 10%.
I think it would be something around like 30%, I would say.
That's still
30
a lot.
to 40. But like I said, it depends. In an ideal circumstance, I think it makes most sense to pursue a separation agreement. I think that people feel more empowered as being part of the process, taking ownership of it. I think it must be a very difficult thing to have someone who doesn't know you impose something on you. And some people just can't accept that outcome, and for various reasons. But I think that it is inherently better for people to take ownership over the process, to have meaningful discussions, even if through their counsel. It can be, like I said, far less adversarial in a way. Like I said, having said that, I've negotiated separation agreements where I've thought, man, this is a great deal. I cannot believe, especially if someone's self-represented, they don't know the law, so they don't realize that what is being offered is completely consistent with the law, completely reasonable. But understandably, if they don't have legal counsel, they don't know the difference. And so what's difficult in that situation is it can be hard to negotiate a separation agreement there because they're just taking stances that are completely ridiculous and outside of the law. So the benefit of going to court rather is you've got timelines, right? It says you have to provide this within 30 days, and there's consequences if you don't. So it keeps, pedal to the metal, people moving, and keeping the process going. And then when you do have a case conference, even as a lawyer, I find them helpful because not everyone's going to analyze the facts to the law the same way. So
what's a case conference? You
go to a case conference before a judge, which is without prejudice, meaning that the and it's private. And so it's an open, informal conversation. A judge reads your materials. They read a summary update, case conference brief, bringing them up to speed of what's happened. And lawyers identify what are the issues we really want your feedback on. And so you use that case conference and settlement conference to have a neutral, judge's opinion.
Do you find that
to say
really productive?
It can be. Some judges are quieter than others. So I do appreciate when a judge really takes the time to, and it's hard because it's not evidence at this point. They're not making a determination of fact because there's been no testing of the evidence. This isn't affidavits. This isn't cross-examination. This is, here's my story. Here's your story. And a judge saying, hey, where can we agree? Where do you agree? Let's look at where you agree, where you disagree. What evidence do we need to broker this right now?
And so
they'll issue orders that say, they're called procedural orders that say you need to disclose this document or that document. And the goal of this exercise is to almost like the list you have of questions right now. Okay, we dealt with this issue. Good.
Yeah.
That issue's gone. That's not something we have to deal with in trial anymore. We were able to resolve that.
But is it really resolved until, like, yes, technically you've agreed on it, but then you could have somebody say, well, like, you know, without prejudice, right? They could agree, and then they gotta say, well, now you're going after full custody of the kids. I'm not gonna agree to the buyout anymore.
Oh yeah, that back and forth happens all the time. But at the end of the day, once you have, like, let's say parties have agreed on one issue out of 5, that one issue does become a court order. Right? That's an order on consent by both parties. So that's a judge saying in a case conference or a settlement conference, hey, if I were the judge in trial, this is how I would resolve it. So if you're not going to budge right now, the risk to you is you're forcing this to trial and you're going to risk adverse costs against you.
So, okay, but with the case conference, right? Like, you're not necessarily going to get the same judge.
No.
Okay, but the judge's notes are in the file?
So they're in the file for, as I understand it, I'm not a judge, but as I understand it, just for the next judge who's doing another conference. But those notes, those discussions cannot be relayed to the judge that is presiding over the trial, because the point of case conference and settlement, they won't. The case conference and settlement conference is really meant to help parties understand their positions, come to settlement.
Yeah.
But if they don't, a judge can't force them to settle.
Well, and I guess the point too was that just the confidence that it is actually without prejudice. Because if another judge says, hey, you better do this, and Tyler, you better do this, and I say, no way, then then the next judge at trial has it, it's going to be hard for him to lean in a totally opposite direction.
Yeah, I think that, there's times where case conferences actually aren't very helpful, to be honest, because a judge doesn't have enough evidence before them, especially when it's like a credibility issue. So they can't really weigh in to give much of an opinion. They can simply say, this is what the law says, here's what this looks like. And really what they're trying to do is whittle the case down so it's less complex, and hoping people become reasonable. But that's why I raised this with respect to separation agreements. There are times where it's just, you're not going to get anywhere.
No.
And so I also want to make clear that if you file an application in court and your case conference is 3 months from the date of filing, there's nothing stopping counsel from getting on the phone with one another and trying to settle issues before that court date. That court date is really used in circumstances where you've tried to do that and both counsel continue to disagree. And so as counsel, you stand to benefit from a judge's opinion, because then you can say, all right, if this is what this judge is saying, then perhaps this is how we're going to settle.
Can you get, as counsel, do you guys actually get on the phone with one another? Or is it just like lawyer's letter, lawyer's letter, lawyer's letter, lawyer's letter?
It depends on...
I'm going to say it a couple more times. Lawyer's letter, lawyer's letter.
Yeah. It depends on the lawyer, right? I think that a lot can be lost in letters, and some lawyers can... approach their case up here so high with a tone of aggression that they're kind of posturing. And so there's times I'll read a lawyer's letter and see that what they're proposing in the outcome may be close to, if not exactly, what my client wants. But the song and dance of the paragraphs surrounding that would suggest otherwise. And so if my client reads it... yeah,
they're going to get pissed off.
They're pissed off, and I have to sort of say to them, okay, let's just ignore the posturing
Yeah.
and the jabs that have been sent throughout, and look at this acknowledgement of where you do agree. And so, you know, there's no one size fits all model. I think that each case demands a different approach. And it also just depends on the personality of counsel. I'm a counsel who thinks, why not get on the phone? Why not have this discussion? Why not send that letter? Why not make an offer? And beyond that, you do have an obligation to try and settle outside of court anyways. But it's tough. There are some counsel who don't respond and won't respond for months. And that can be very frustrating for myself. It can also be very frustrating for my client who thinks that maybe it's their ex that's dragging their feet, when in reality,
it could be the lawyer.
It could have been the lawyer.
Yeah. So, okay, so I got a couple quick ones for you, okay? The lawyer's letters, okay? There's not like some unofficial rule where they always have to be delivered on a Friday.
No.
Okay. Because like I've heard that where like you get a letter on a Friday and it just ruins their whole weekend. And then the other thing is we need a response by Monday, or we need a response by Tuesday. What's the obligation? Like the lawyer's letters to me, sometimes they're like really short, sometimes they're really long. What's the obligation to respond to the lawyer's letter? And does that show a judge something down the road if you have to go to trial that's saying, well, geez, these guys are non-responsive, but then the lawyer's letter was just so far out of this world, I'm not going to even spend the time to respond to something like that.
That's a really excellent question. So the Law Society is the regulatory body that governs lawyers. And there's bylaws within that regulatory body we have to adhere to. There's ethics of our profession. And really it says, you know, you have a duty to respond to opposing counsel. You have a duty of competency. You have a duty of being a zealous advocate. You have a duty of being a friend to the court. You can't mislead the court. You can't dupe the court, right? So there is a high level of ethics. Now, it can be tough. Are you going to make a complaint to the Law Society about every counsel who doesn't respond as timely as you do? No,
but
of course
do you
not.
Have to? Like, is there like what's timely, right? Is it 2 days? Is it a week? Is it 2 weeks?
That's the frustrating lawyerly question, right? Is what is that? And I think the lawyerly answer is it does depend. You know, if there's a timeline where there's something bearing on a response that, with or without, it's highly consequential, then you do want a timely response. And that could be, 2 days from now,
You can't force that.
I can't force it. I can suggest it.
But does it suggest anything if you go to trial? Like if you say 2 days and then they're like, well, like 2 business days, and then they respond in 2 weeks.
Right.
Realistically, that's not like life or death, unless maybe it is.
The way in which, so lawyers will write their communications either with prejudice or without prejudice. And most of the time it's without prejudice. There's a recognition that you're not kids, tattling on one another while you're playing in the sandbox here,
but that
right?
happens though.
It can. But I think that you're doing a disservice to your client. Your ego's just speaking, right? How far ahead are you going to advance your client's goals if this is how you practice? So to your point of if someone's being reasonable and they're trying to advance settlement in advance, how can that be accounted for at the end of trial? So the answer to that is what's called in family law an offer to settle. It's a formal offer that isn't without prejudice. Or it isn't in so much as at the end of a case, when it comes to determining costs, and the winner's presumed entitled to at least a substantial basis of their costs.
But we know there's no winners.
There can be, but it can be, there could be divided success, where 3 issues this person was successful, 3 issues this other person was. And usually when there's divided success.
I'm going to use that. This is divided success.
Yeah, then a judge will say, oftentimes I'm not going to order costs against either party, right? But if there's a
Does
prevailing.
Does that happen a lot?
Yes. Yeah,
the judge awards costs.
It doesn't happen often, to
doesn't.
be honest. As much as the law says you're presumed entitled to cost if you're the winner.
Yeah.
You aren't necessarily going to receive your full costs unless you can prove that the other party acted in bad faith, which is a very high threshold.
And they would have to be very, very unreasonable.
Yes, they would have had to have brought frivolous and vexatious motions, not responded to materials, and really added cost to your case because of their negligence in their dealings. Okay. But if you have served an offer, so let's say you write counsel and say, I want a response in a week. Well, because of their failure to respond isn't in and of itself going to help pad your cause for costs. But if you serve a proper offer to settle in the form and you follow the rules of what you have to abide by in serving an offer to settle, and in your offer you say, this is how I want to resolve it, and you clearly identify the terms, and it turns out you've served that, let's say, January 2025, and it's now February 2026.
Yeah.
You're in trial, you win. And everything that you sought from the other side in settlement that is in that offer to settle from a year and a bit prior, if that is what you were ordered in the end, then a judge is going to say, okay, look, you could have resolved this 12 months ago. So that puts parties in litigants in a very strong position to say, I want all of my legal costs that were incurred between the date that offer to settle was served and this decision came out, because we could have settled this, right? And so you're not necessarily in that situation bringing, the emails between lawyers up of, they didn't respond or what have you. The more proper format is to give that offer to settle, and then a judge will consider that when they're considering costs.
So does it matter? Okay, so that makes sense. So the costs are awarded, not very often.
But I would say they can. So there's costs. I don't think it'd be a fair statement to say costs aren't awarded very often. It's the amount. I think people just assume. Like if
they spend $50,000 on fees, they might not necessarily get $50,000, but they might get like 20.
Yeah. So there's what's called partial indemnity costs. That's maybe 30% of your bill. Then there's substantial. 50 to 60, 70, and then, full indemnity would be the full amount. But the full indemnity...
Have you ever had that?
I have had full indemnity once.
Wow.
Yeah. And I even tried to get the costs that were incurred prior to the application to court. And it's a pretty high threshold to get costs that were incurred as a result of trying to negotiate in advance of filing in court. But this is a good segue to say to people, I don't want to deter people at all from trying to negotiate a separation agreement and trying their hand at that first and leaving, an application to court as a last resort. Yeah. Having said that, there is that tipping point where people feel like, I've already spent so much trying to do this. And the reality is, it's very, very rare, if not almost impossible, to get the costs that you spent prior to your application to court ordered, by a judge. It's what were your costs from the date you filed. So if you've spent $10,000 over the course of 6 months trying to negotiate something, those costs aren't necessarily going to be considered by a judge.
So, and that's where we kind of go back to that's where some people, if they did have the money to pay that and it didn't matter, they could use that as a negotiating chip and just extend it, and then just say, well, you know what? Okay, fine. I want this. I've heard cases of real property, and they're just like, the one person's not settling. I'm not settling until I want my price. And then the spouse is like, fine. Take here, you buy me out for this. I'm sure you see that all the time, right? But I don't necessarily think that that's a loss, for, what did you call it? Mutually beneficial loss, or a split. Anyways, divided success. Because I think mental health goes a long way with stuff like that,
absolutely.
Right? So, okay,
it's hard. I've had people where they've said, look, like, my ex, it's a marriage of 35 years. They're like, my ex is devastated. I still care for them, but I can't be in this. And they do have a heart. They're not trying to screw them over. They're very upset themselves. And oftentimes in that situation, they don't want to go to court because they already feel bad. Yeah. They don't, their mental health, they're considering. The mental health of the other party they're considering, and they see it as inherently adversarial, like that this is really stoking the fire. Yeah. And so I've seen people with that disposition, and it's not all the time, but I did have a client where they said, negotiations are happening even though it's slow. Yeah. It's been 2 years. We couldn't get an agreement on selling the house. And I kept saying, I'm really sorry to say this, but this is going to be the pace unless you go to court. And finally, they said, okay, we have to now, because there is that tipping point of, it's a cost benefit analysis of, you can't continue to expect a different result if someone's really not participating in the process.
And I like, it's funny because I've heard, like, I mean, I hear about divorces all the time, and I've heard of people like phoning me, getting a value, 2 years later it's still not finished. Mm-hmm. And I remember when my brother split with his first wife, he was just like, here, like, he he didn't fight for the TV and the and the savings and the equity in the house. And I'm like, you go back there and you get, that's your money. And he's like, and it was like, at the time I was like, what? Like, I was like disappointed for him. But then when I look back, I'm actually pretty proud of him, because he was just like, and I just didn't want it. I don't want to do, he didn't want to fight. He just like, he's like, it's over. Yeah. And it's kind of like to have, there's not a lot of people, he doesn't care about money, right? Like, so there's not a lot of people that would happen with, because it gets into this,
It can.
Right?
And what I'll say to some of my clients, depending, I'll ask about the nature of the relationship. Like, you're separated, but can you still have a good conversation? Or can you still, even if maybe not a good conversation, could you write one another? Because sometimes it is easier and swifter and faster to not have things convoluted between lawyers. And I'll say to my client, can you, out of the 7 issues that need to be resolved, maybe not the legalese language, but do you think you and your ex can agree on some of these? And if so, fabulous. It's less time and money spent on me negotiating with opposing counsel on those issues. So it is great when people can agree on 6 or even 3 of 10 issues, and then the others are just left to your lawyer to be a good sounding board for you and to advance your interests right through counsel.
So quickly, what's the quickest separation agreement that you've done?
This is wild. So I don't want this to be a precedent where others can expect this, but I think it was a month and a half.
What's the longest?
So far 3 years.
Holy.
And that's when it was time to go to court.
Wow. Yeah. Does it matter the reason for the separation? If somebody cheats on somebody, like, does that matter?
No, no, with the caveat that if there was infidelity in the relationship, you can pursue a divorce based on that ground. Okay. And the divorce process is different in so much as, and it's muddy, you have to serve the third party who became part of the extramarital affair, and then prove that it happened. And so some people think, okay, well, the legislation says this will be a faster process, but in essence, it's not, and it's probably a very painful and damaging process. And at the end of the day, it does not change whatsoever
what's fair,
your entitlements.
Yes.
So the law does not punish you in terms of who's paying support or how your assets are divided. There is no consideration of why you separated. That's not a factor in considering all of those other issues of property and child support or spousal support.
And does it matter? Does it affect anybody's standing if one spouse leaves the house?
It doesn't
like the matrimonial home.
Yeah, so it doesn't necessarily remove their standing. So I don't know what you mean by that, but what I'd say is,
can they get back? I guess if you leave, you still have your rights to your real property.
Yes.
Right?
Yeah.
You if you leave, can you come back?
So if you have left, you and it's not temporary but prolonged, and you've said, I'm living somewhere else, then you've effectively given your spouse de facto exclusive occupancy of the house. Okay. Now that person can't just lock the doors and forever deprive you of access, but you've given them de facto exclusive possession at that point, which means that they have the right to say, I need to know when you're coming and going,
Can
right?
they
Or
lock
if
the
you're
doors?
returning.
Can they change the locks?
Technically, no. You can't lock someone out. The matrimonial home is sacred. It's very different than common law. So in marriage, even if you're a spouse who is not on title to ownership, you have the right to occupy the house. So if both parties have separated and there's emotions involved, there's so much to resolve still, oftentimes people are still living together while they're separated. So separation doesn't require one party to physically leave the house. You can be separated and still living under the same roof.
But it doesn't go against them in any capacity, does
right,
it? Other than that they can't live in the house and they've still got to share in the bills.
Yes. Now, one of the biggest issues is that if you're a spouse who's left, right, and oftentimes the spouse who has left isn't paying half their share, right, of the carrying cost of the matrimonial home. And that gives the spouse who continues to occupy it, and if that house is later going to be sold, and now obviously the value of the house has appreciated, right, because the person paying the mortgage has increased the equity in the home, the law says that the spouse that's going to benefit from the appreciated value of the home is required to pay a post-separation adjustment, which is they have to pay half the carrying cost of the home that they didn't pay.
Or the spouse that left.
The spouse that left did.
But they still get the appreciation on the asset.
Right. So if the spouse that left hasn't paid and they're on title and they haven't paid towards the carrying cost of the home, and the house sells a year later, then the net proceeds of sale, the standard is that they would remain in trust until you've resolved who is owed what, because that's security for payment. Parties can agree to release a portion of those funds so that they have some money in the meantime. But the spouse who remained and paid for everything certainly has the right to ask the other spouse for reimbursement of their 50% share, because they've now benefited from the appreciation in that asset.
But they wouldn't. The spouse that left would still be entitled, like, given he's paying the fair share, he'd still be entitled for the appreciation.
Yes. Yeah.
Okay. And if he didn't pay his fair share, is he still entitled to, or is that just a
so you're entitled to half the share of the net proceeds of the matrimonial home, and that's why the spouse that paid it all, they don't have to, but you can ask for reimbursement of the other spouse's 50% share contribution to the house. Now, the other piece that this opens up is, once a spouse has asked for your 50% share contribution for the period that you didn't contribute, post-separation, only post-separation, not prior to separation, the spouse who left and is now out of the house can ask for occupation rent from the spouse that remained.
Okay. Or could they ask for half of their rent to be paid?
It wouldn't be that, maybe in a separation agreement, but that's not a remedy by the courts. The courts will say, okay, if you're asking for half the share contribution of, this expenses related to the home, but the person who's going to pay that has not enjoyed the benefit of residing in that home and now has been ousted, even if that's their choice, they can, in defense of that claim for 50% share of the carrying cost of the home, they can ask for occupation rent. And so usually a portion of what's determined to be their share of what rent would be for the house is offsetting against, the carrying cost. So let's say, for example, you've got spouse one who remained in the home, paid 100% of everything. They now say, pay me, your 50% share.
Yeah.
The spouse that is no longer living there says, well, I didn't get the benefit of the house. I had alternative housing costs, right? So I want to be paid.
Market rent's $2,000. I want $1,000. So
then you have to put forward, and it's a discretionary remedy. It's not automatic. So this is something the courts can order.
I'd imagine most people would probably just take it out of the equity in the house.
But some people do pursue occupation rent, and like you said, you the math on that is somewhat varied, but essentially you're looking at, you need a letter from a realtor or someone else indicating what the fair market value for that house is. If it's $2,000 and you divide that by 2 to say, well, there's 2 people here, so then market rent would be $1,000. And where this concept of occupation rent becomes sort of a perverse and unfair, inequitable concept is where, because of the market these days, you could have rent be far in excess of what the mortgage payment is. And that puts the person who remained in the house paying the mortgage now having to pay more. I am curious to see how courts are going to resolve this issue, right? Where market rent is far in excess of your mortgage payment. And so what I've seen so far is there is there's flexibility in determining that, because ultimately the court is going to look at what is the outcome here, right? If the purpose of this was to balance, people's equitable position and their rights, we're not going to pursue an outcome that is inequitable when the goal was equity.
So, and that's interesting because I didn't know that. Now, if I'm common law, right, and I'm not married, but we were, I guess we both jointly, if we both jointly own the house, then the 50-50 rule still applies.
Yes.
Okay. If I'm common law, we buy the house together, but my credit's crap. My partner, her credit is really good. So we determine at that time where we give 50% of the down payment. It goes into her name. We think we're going to get married anyways. We share in all the bills. What happens there?
Well,
if I leave, is that now a big implication on something else?
Yeah. So that is a scenario I don't think anyone wants to find themselves in, because basically in your scenario, the title, right, is in her name. Yeah. And even though you've contributed to the down payment and you've contributed to maintaining the house, right, and therefore appreciated value of the home, you're not necessarily presumed entitled to 50%, but you're not screwed. There's something called a constructive trust. And so people in that circumstance can say, look, I contributed X amount.
And I can prove it.
And so I have, in equity, a beneficial ownership to this property, even though I'm not technically on title. The remedy to that is not putting someone on title, but let's look at what was your equitable contribution to this home, looking at your dollar for dollar contributions. And you can come up with a percentage even to say, all right, then when the house is sold, you get 70% and this person's entitled to 30%.
But if that one party left, then would they stop, like if it appreciated, would they still have rights to that appreciation?
No.
So then they leave, and then a year later everything's dealt with, but the house has gone up 50, $100 grand.
Right.
They still have to do it as of when they left.
Well, yes. I mean, it is an exercise at looking at what were those financial contributions, what period were those, contributions made. So it is an exercise in sometimes parsing out like the periods of time. And for example, it can be easier if, for example, you have the date of separation, right?
Yeah.
Then you get a realtor to identify what the value of the house was as of the date.
Realtors are the worst.
As of the date of separation. And so what that means is you're entitled to the whatever percentage contribution you have valued as of the date of, separation.
Yes.
If the house sells, 2 years later or a year later for a larger amount, you're not entitled to that because you didn't contribute, and you're entitled to what it was at the date of separation.
So if somebody's out there and they, that situation, credit's crap, one partner puts the house in their name, would you recommend some sort of an agreement, like a cohabitation agreement or anything like that?
Absolutely. Yeah.
Okay. And you see that's not uncommon?
I think it's becoming more common.
Can you register that on title? Or is it just an agreement that's held with the lawyer?
So you would be able to register on title that that there's a spouse if you're married.
You're not married?
No.
Okay.
There is in law a mechanism, I won't get into it, where if you are pursuing a claim under constructive or resulting trust saying, I may not be on title, but I have equity in this and I want a percentage of the dollar for dollar, not dollar for dollar contribution, but something that reflects that equity based on my contributions, then there's a way in which you can file an application or a motion in court to stop the sale of the house and or any disposal of property or assets that would otherwise undermine your entitlement to something at a later date, right?
Because and that would be like a lien anyways, right? Type thing?
You can't put a lien on in that situation, but you are able to, there's about 3 different routes people could take to say, I'm not on title, and unless, a bank or a Schedule 3 lender who doesn't adhere to the same protocols as Schedule 1 banks, let's say, you are the one on title and you go to the bank and just want to deplete the equity in the home by continuing to register various credit against your house through a HELOC or another mortgage. The person who's claiming equity in the home and is waiting maybe a couple years till they're successful on their argument that they're entitled to some equity, they're at risk of that equity being completely depleted by the titled spouse, either registering, various credits against the house, depleting the equity in home, or selling the property. So there's many ways in which you can protect yourself against that from happening.
Okay. So then...
but in terms of, that's sort of the reactionary process. But to get ahead of that, people should be doing a cohabitation agreement. They should be doing a cohabitation agreement is between people who are common law. And then oftentimes that agreement can become their marriage contract, right? That's signed before they're married, with maybe tweaks to their agreement if they want to do that jointly. But it really is...
The cohab turns into a prenup type thing.
Yes, it can, yeah. But you can also modify it at any time so long as you're doing that jointly. So a cohab or a prenup is excellent for several reasons, especially if you're common law. If you are the person who made the down payment, maybe you each contribute 50-50 to the carrying costs, but at the end of the relationship, you want your entitlement to that down payment, right? Because that was your sole contribution. So you would be able to include that in a cohabitation agreement. Or you've been together 3 years. That's when you're officially common law, with the exception of if you've had a child together, then you're common law after 1 year of cohabitation. But cohabitating for 3 years, jointly integrating your finances, that really can expose you to a spouse in the common law situation who has higher earnings, to have to pay spousal support. So spousal support is not just a concept that is applied to
married individuals. So you can pay spousal support with common law.
Yeah. So the main differences in, what laws and rules apply to common law spouses versus married is the matrimonial home.
Yeah.
In a common law situation, even if you've been together 5 years, if you're not on title to that property, you can be asked to leave.
Wow.
And you're required to leave.
Even if you pay like, let's say I own a home, and then my partner comes in, pays half of everything for 10 years.
Yeah.
And then after 10 years, I might get lost.
Yeah.
Is she entitled? Yeah. Is she entitled to anything with what she's paid or put into it?
But that's the concept I was talking about earlier, where you may not be on title, but you can, and so therefore you don't necessarily have occupancy rights. So occupancy rights.
So even if you've been there for 10 years, that someone who's on title can kick them out?
Yeah.
Wow.
Yeah. Yeah. Whereas if you're married
you can't.
And you're not on title, you're entitled to occupy. You have the right to occupy unless
spousal consent as well, right?
Unless a judge, orders that, one spouse can remain in the house. But that's something, there's occupancy rights, right? And that's what we're talking about in common law. If you're not on title, you don't necessarily have occupancy rights, but you still can have the right to pursue, your equity in the home, but that's not necessarily going to save you.
You got the right anyway. Like you could pursue it anyways, whether or not it's worthwhile.
Right. But that doesn't keep you in the house.
Would it change if there is a child?
No.
So if I'm just going to do it again. Okay. So if I have a house, I have a partner, she comes in, we have a child, we're together in the house for 10 years. I can kick her out and the child?
If she's not on title to the
really?
House. Yeah.
But then I guess, then in fact, there's support as well because now you have a child together, right?
Yeah, but there's child support,
yeah,
right? And then there's spousal support. And so
but is it
the determination of those are
spouse?
Different. Pardon me?
Is it spousal support if it's not your spouse?
Well, if you've lived together and for 3 years and are therefore common law,
that's your spouse.
That's your spouse in common law. And so you could pursue spousal support.
Okay.
If you can pursue it, whether you make out the grounds to qualify for it, it's another thing. There has to be, proof of, an income disparity here.
So what happens if two young people are getting together? They're married, not married, it doesn't matter. You'll probably tell me it does, okay? It always matters. But one of the parents gives them $100,000 for a down payment, and the parents worried, because we see this a lot, but the parents worried that if something happens, well, now all of a sudden those two are splitting. Yes. They're both on title. Both two of those have to split my money. Can I make sure that my daughter gets that or my son gets that in a separate, or it comes back to me?
Yes, and I have seen this issue arise so many times where parents are trying to do right on their kids. They're trying to get their lives started. It crumbles, and they're wondering, where is my investment? It's presumed that gift of the down payment or the house even. I've seen parents buy a house for their kid that's getting married, and suddenly 5 years later, they're separating. And the law presumes that was a gift to both spouses.
Yeah.
And so the best thing that those parents can do is go to a lawyer and draw up an agreement. It could be a trust agreement. It could be a repayment agreement. You can structure it any way really that you want. And then ideally that agreement is embedded in whatever prenup, which is synonymous for the most part with a marriage contract.
It's not on title. I guess you could register it after.
You could. Yeah.
Okay.
Yeah.
So then,
depending on how it's structured. But I see this all the time, and it's really tragic. I've even seen some parents get really creative where
Yeah.
they say, if the marriage lasts 5 years,
Yeah.
but you separate after 5 years, my daughter, is going to receive,
X.
the portion of the down payment, or it comes back to me.
Yeah.
But if you are married 20 years, then, you can divide whatever it may be,
Yeah.
that's left over. So you can really structure the agreement in terms of what you're gifting to your kids, but it's presumed to be a gift. Like some people, there's no documentation, and I'm always shocked. $50,000, $100,000, like a lot of money is being given to children with really good intentions, but it's unclear. Was this a gift? Was this a loan?
But I guess if you look at it from a bank perspective, okay, they're signing gift letters, right? Like for you, if
the presumption under the Family Law Act is this is a gift that both spouses share in, unless you have documentation otherwise. And so people are going to spend, and I've seen it, parents have spent a lot of money, spouses have spent a lot of money arguing over whether this was a gift, a loan, and or whether the house is in fact, in terms of the equity of the home, the matrimonial home, whether the equity is to the benefit of the parents or the kids living
and I guess
there.
that's something to consider as well. Like I think most parents give the money because they want to help out. If they can get their money back, then that's great. But I guess that's another factor that you could put into the equation. That if the house is sold, and if it's $1 million house and they give $100,000, they 10%, then they get 10% of the appreciated cost.
Yeah.
Now, I guess in that 5-year situation too. So then, because you could structure it where if the marriage lasts 5 years or 10 years, then it's both of yours, and that's okay.
Yeah.
But if it's 3 years or under 5, then that money or that's my money as dad or mom, right?
Right. So you want those intentions written out with a lawyer.
Yeah, it's funny because these like prenup, agreement. We have a agreement with the parents on what they're going to gift. Like you got to normalize these conversations, right? Because a lot of people are like, well, how do I don't want to necessarily say, honey, I'm willing to give this to you, but that douchebag that you're married to, I don't think he's going to last 3 years. So like, let's just put a cap on it. Like it's kind of like I guess it's kind of like a prenup where like you're like, well, you don't trust me,
right?
You don't think that, and I mean, I'm sure you see like if I ask you that, you'd say, geez, stranger things have happened. I've seen more than my fair share.
Yeah.
And I think a lot of people, you're just securing your I guess your equity or your portion before getting into the relationship, and then the parents are securing theirs.
Absolutely.
But I do feel like you could have a course just on that.
Yeah.
Just on how parents bridge the gap, what contracts they're going to sign,
Yeah.
how they deal with it, right?
And it's not very costly, right? Like I think that it is not going to cost you a lot of money, specifically if it has nothing to do with inheritances or corporate structures, and you're worried about, who's going to assume the business. Like, let's just say most people, middle class and lower middle class people, let's say their parents even give them $30,000. It is not a complicated thing to spend. Maybe even it's $1,000. It probably wouldn't even be that much, but let's say it is. It's within maybe $5,000 or less to, most cohabitation agreements, prenups, marriage contracts are $3,500, maybe give or take a little bit more. But imagine what that saves you.
Yeah.
Because even in a streamlined, cooperative separation, for the most part, you're probably spending at the very least $10,000 to $15,000. And so, if you're a parent, in particular, let's say you've gifted your kids and their new spouse a house, even, and there's no mortgage on it, and they haven't contributed to the appreciation of the house, then you're going to be battling. You're going to have to file motions in court to stop a sale of the house because maybe you're claiming that you're a bare trust holder, and that even though it's on title, you're really the one who owns or at least has 100% beneficial equity in the home.
Like, that's hard to prove, no?
It can be, but the point is, the difficulty of proving it is why your legal costs are going to expand. You can eventually get there because basically the law takes the position that it's pretty shocking that someone would
just give
something of $600,000 or $1 million value without consideration or something in exchange. That's not a fair bargaining power, right? So you can rebut that presumption by saying, no, this was a gift. And then you're going through all the emails that were exchanged, trying to figure out the intentions of the parties. All of that costs. You're going to spend maybe $150,000 on arguing that, whereas you could have spent maybe $1,000,
$3,500, right?
or $3,500 for the marriage contract to figure these things out in advance.
So okay, so then, and I mean, I think that's important. Like, I think if everybody, you have 3 people sit down at a table and say, hey, this is what this means. It's pretty easy. It means that the money that I'm giving you to help you get a mortgage is mine. I'm not going to take any equity. I'm not going to take any interest on it. But if that house sells, it's mine. It's important. You know that, and you know that. Everybody signs away, and we're good.
Right.
But it's hard to do that after the fact.
Yeah, and it's not necessarily. It depends on the circumstance. It's not necessarily that the whole house is theirs, right? But you're protecting either your down payment or your investment or a portion thereof, right? And as much as people will think, oh, a prenup or a marriage contract may signal that there's insecurity in the marriage or that they're doomed or people are untrustworthy of one another, I couldn't think of something more trustworthy. When you think about couples who are really intentional and thoughtful, they're discussing the boundaries of their relationship. Not everyone has the same boundaries. Whether that be in terms of, I'm never going to go to Easter, by the way, or I don't celebrate this. Couples talk about so many parameters of their relationship that it, to me, makes sense that the parameters of the relationship and what happens in their relationship from a financial perspective is also discussed. And the reason being is because if not, you're being told by the Ontario government or federal government, based on their legislation, how you're going to resolve your separation. And not everyone agrees that the terms that are required by law are fair, or how they want their relationship to look. So I think if you have the autonomy to establish the boundaries of your relationship, whether it's intimacy or other things, then do a prenup that also gives you the autonomy to decide, hey, maybe I'm not going to touch your pension. We're going to divide our assets that we both contribute to and they grow, but I'm not going to touch your pension. Or maybe I'm not going to pursue spousal support, or those sort of discussions could take place.
So you would recommend a prenup no matter what?
I would.
Okay.
Yeah.
And then
it gives you certainty. It gives you clarity.
Yeah.
I think it gives you transparency too about, the person you're marrying. It's not a romantic exercise, but who knows? Someone could say they earn $200,000 a year, and then you buy they move in with you and you're expected to share bills, and suddenly that was never the case. I mean, that's a really far-fetched scenario, but it's shocking how people will have a lifestyle that does not accord with their earnings whatsoever. And a lot of people are really living off debt, and ultimately that debt is going to deplete or at least minimize their wealth, and therefore put the diligent party in a position who never incurred debt and really managed their money to have to pay, or share in some of their wealth
and those
to the less diligent party.
Like, do they matter? Like, if let's say I'm a nurse, okay, or I'm a teacher, and I'm just starting. I'm married. I've been with my spouse. We have a prenup, but I just start my teaching career. I've got my pension, right? If that pension is in the prenup, okay, then 20 years down the road, it's still his or her pension, right? Yeah,
a prenup is a contract, and and it's going to be upheld by the courts. And so there are definitely circumstances where people can challenge, and we can't control what people pursue as a legal case in any event, right? People think they have a case all the time and they don't. So, but the reality is courts do prefer certainty. They prefer to defer to contracts that have been entered. And so it is going to be a very high threshold to get over to justify untangling a prenup. Certainly, spousal support provisions can be adjusted if there's certain contexts or circumstances that would give way to a really unconscionable result, but there's language included in these prenups that say, even if this person gets sick, even if this person's unemployed for reasons of illness or disability, this spousal support provision, it's called a Miglin agreement, is not ever going to be overturned, even if circumstances are extremely dire for this person. Wow. There can be a review of spousal support provisions. I'm not saying there isn't some flexibility in the law at a later date, but it's a very high threshold. So if you've got proper financial disclosure, which is required in a marriage contract, in so much as if a court just sees an agreement where you get the house, you get the car, and that's it, and you basically walk out of this with like millions of dollars and you are destitute in poverty and you've relinquished all of your rights and you haven't exchanged financial disclosure, a judge is likely going to look at either your separation agreement or prenup and say, this is inconsistent with the overall purpose of the law. It's unconscionable.
Someone's under duress or something.
Yeah, someone was under duress. This wasn't fair bargaining. And a lot of my clients, and a lot of, not just my clients, but many clients in family law, hear that we ask for financial disclosure and to fill out a form that outlines what their assets, income, and income is. And it is a hassle and it is frustrating, but I don't want to proceed without that because you don't necessarily know your bargaining power. I can't give you exact advice on whether you're giving, something up or not. Yeah. And then more importantly, it does open the door for courts to review a separation agreement that's being challenged. And if there's no financial disclosure, it just opens that door more for it to be overturned.
That's interesting. So, we're going to go back to separation agreements. One thing I have to ask you is, just in your experience, who's harder to deal with, men or women?
I don't think that this is a gendered issue. No, I don't think it's a gendered issue. And
can you tell, is it the quiet ones? Is it the loud ones? Is there anything like that?
I don't think you can tell per se. I think you can tell based on the tone of an email. It's always funny when someone's really sharp and indignant as if they know everything, and really they've just cut and paste some really awkward AI or chat GPT sentence that it makes them think that they sound good, but really it doesn't make sense at all. Yeah. So I think that maybe I would find the person that's more difficult to be the person who really feels wronged by the separation or their partner.
Okay. So emotional aspect.
Really emotional aspect. And the other more difficult would be someone who, and I get it oftentimes, is this person was intentionally underemployed, didn't try to overcome their difficulties and get another job.
That happens a lot.
I've carried 6 jobs to maintain all this, and now because they'll say lazy, their words, I have to pay them spousal support. And so it's not that they're difficult, but it is very difficult to deliver the news sometimes where it doesn't seem fair, right, in these circumstances. I represented a woman who was an emergency nurse at the hospital, and her ex-husband had just been incredibly unmotivated, I'm not sure if they had mental health issues or what have you, and I'm certainly not trying to stigmatize that, but just really I don't think that was involved here. Just really took advantage of the situation. And here she was just taking extra shifts and like not sleeping and working overnight. And it really was difficult to say to her, there's a strong chance, more likely than not, that you're going to owe this person spousal support.
And he's probably done it to somebody else before.
It happens.
Right?
It happens. Yeah.
So let's break the separation agreement down. How are we at for time, Kyle?
We are at 2 hours, 7 minutes.
Oh,
Okay.
Good. What's your timing? What time
I
do you
have to leave the last, very last would be 12:30.
What time is it?
It's 11:51.
Okay.
So 20 minutes or so. Okay. So we'll do this quick. So what's involved in a separation agreement? Custody, assets, support payments, and then maybe cash, right? Or
really
savings.
So when you're separating, you're looking at who's keeping the home. Are we selling the house?
Yeah.
And looking at this is in the married context. Equalization, that concept of you're sharing in half the difference of your net wealth that you've accumulated throughout your marriage.
If you're married.
Yeah. Then you're coming up with a parenting plan.
Yeah.
And then you're also looking at, okay, maybe we have 2 cars that are in both of our names, but really one person drove one person drove the other. Who's going to take those cars?
Yeah.
You're looking at is spousal support going to be paid? If so, what amount and for how long? Is it going to be a lump sum payment, or is this going to be a payment made monthly?
Okay.
Or are you waiving your right to spousal support? And then you come up with a parenting plan, which is who's making the major decisions in this child's life? Where are they residing primarily? What kind of schedule are you going to have in terms of a regular parenting schedule versus what happens in the summer months or winter months and there's holidays? And then that impacts child support. And in a separation agreement, you can consider, am I going to equalize our assets without consideration of a pension?
Yeah.
Or am I including the pension? And so there's a lot of compromises that can take place, but really you're looking at what's happening with this house. How are we managing our children going forward? How are we dividing our assets? And what child support and spousal support are being paid to one another. Another issue that can arise is, your health benefits, right?
Yeah.
Are you usually like the administrator and the terms of health benefits will say, your spouse at least cannot remain on them a year past, your date of separation.
They can't go after you for that, can they?
So you can.
I have a privilege. I'm used to getting health benefits, and now I can't have them anymore.
Right. So that's a consideration with spousal support.
Okay.
So oftentimes people remain, or children will remain on health benefits. Then there's life insurance policies, right? And so life insurance policies and who's the beneficiary, whether the spouse is going to remain that, is something to consider. Most of the time, though, at least when it comes to kids that are dependents, meaning below the age of majority, so 18 and under, with the exception of those that are going to school and residing at home, there's usually a clause, and it'd be smart to have a clause that said that life insurance, you're designating, you're making irrevocable designation that your spouse is going to, should you pass, be the trust of those benefits on behalf of the children. So that, let's say you pass away and you have children and now you can't give child support payments, right? You have that life insurance policy to protect you. And so that would be in place in your ex's name on behalf of the children until such time that they're 18.
So then if you do, so I guess where am I here? Where's my notes? Okay. Custody. Okay. Do you have a lot of the times where people are like, I'm going for full custody, he doesn't do anything to help the kids, he doesn't take them to hockey, he doesn't take them to dentist, in my thoughts here, there's not many times where somebody gets full custody. Okay, I could be wrong, but on that note, how many times do people actually ask for it as well?
Yeah,
because
that's a good question.
That would be, to me, all things like, if someone's not a abusive alcoholic and they work, like to try to take custody away from them, I would say that that's probably, a little.
It's pretty rare, I would say. Yeah. I would say it's fairly rare. I also want to clarify that the term custody is kind of the ubiquitous, like everyone's used to that term. But in law, the legislation has changed in the past few years that says custody is actually a term for decision making. So it's not necessarily the time the child spends.
So 50-50, 100%.
Yeah, so that's parenting time.
Okay.
But custody is when it comes to making major decisions about your children. That is how they will, what school they go to, what major medical interventions will take place, what kind of religion, will they be raised with. Those are major decisions that if you have joint custody, it means that you are consulting one another and you each have decision-making authority over those major decisions. And so it is quite rare, actually, that it depends on the circumstances, but the courts do tend to say, look, there's a benefit to both parties consulting with one another and having various perspectives on a child's life and upbringing, but only to the extent that you have evidence that that person can respond to messages, is cooperative, is child-focused, and is going to make decisions in the child's best interest. If their responses are going to be arbitrary, unhelpful, abusive, or combative, or if they haven't even spent time with the child, or they don't know their nuances, they don't know what doctor they're going to, they haven't educated themselves, then what kind of input could they really provide that's really meaningful to help make these decisions about this child's life? So oftentimes you can see situations where you have joint decision making, joint custody, and both parents have to consult with one another and come to an agreement. And guess what? If they don't, they have to do a motion to court. Yeah. Let's say it's, I want to change this child's school because it's not meeting their academic needs, or they have a learning disability and it'd be better for them to go to this school and the parents can't agree on these things. Then they're forced to go to court to ask for a judge to make that decision. But if you're a parent that's not very involved in their child's life, has there's evidence that you're not cooperating or consulting with the other parent, and you're not making decisions consistent with the child's best interest, then the court will try to find a balance and say, okay, this parent has final decision making, but they still have the obligation to at least spend 2 weeks meaningfully consulting the other parent to make a decision. The difficulty and really the problem I see is that it's the children who are going to suffer, right? If your child needs something immediately, or you've been given a month to decide, even on the lower end of need, like they want to go to this camp, and you're fighting over what camp they're going to go to, and now you've missed out on all the camps, and now parents don't have childcare in the summer. Not only are the parents in a difficult position because of that indecision, but the child's really missed out here. So a court's going to take that into consideration. The next issue is parenting time, which a lot of people see as synonymous with custody, right?
But it's not.
Custody is the old term for decision making.
Okay.
And so parenting
custody
time
is solely based on decision making, but it's not based on where the children live?
Correct. If a child lives primarily with one parent and sees the other parent 39% of the time or less in a calendar year, the presumption is that that parent who has them 60% of the time or more is their primary caregiver, right? And so the presumption is that they're going to make the decisions for that child. But
unless
that's not always.
You could agree on something different.
Yeah, but that's not always the case. Like, there's definitely kind of a preference if both parents have historically been involved and are, for the most part making, good decisions for their kids, that there'll be joint decision making.
Yeah.
But parenting time, if your kids are 15 years or older, or even 13 years and older, and you're in court, then the court is going to appoint or ask for the appointment generally of the Office of the Children's Lawyer. And so that is a program in which either a child has legal representation by counsel, who's interviewed them and ascertained what their views and preferences are. They're also going through an exercise to make sure that the children's views are their own and they haven't been unduly influenced, because when you're 13, 14, 15, 16 and older, you're considered an informed minor. And so what that means is your views and preferences are going to be given a lot of deference when it comes to coming up with a parenting plan.
So you could decide it.
For the most part, right?
If you're a kid and you're 15 or 16, you could say, yeah, I don't want to be with mom 60% of the time. I want to be with dad, or vice versa.
And it's not necessarily, it must be hard for parents to hear, but it's not indicative of their lack of love or love for another parent. Sometimes it's a gender-based thing, you know? But
age,
setting that
right?
aside, basically the court looks at what's the best interest of the child. What parent can meet that? The starting point is we want both parents to be involved, especially if they always were, right? The court will look at, okay, where are you going to reside? Do you have, a child-friendly house where they can live in? Sometimes people are going through a tough transition period, right? Where they're renting and they haven't, until all the property settlement has taken place, they don't know where they're going to live or have the money, right? To have a house.
That would have to be taken into consideration,
Absolutely.
right? Like if I had to rent a one-bedroom apartment because all the equity's in the house, but the house is paid off, and then my spouse can't, I guess they could, but they'd be like, well, you only live in a one bedroom there. So, maybe there's
usually
terms
that's temporary. And in any agreement, let's say the child's 3 years old. Yeah. What fits for that child's needs at age 3, and where those parents are working, living, their work hours even are taken into consideration, right? That is going to change. So you can have a separation agreement that outlines your parenting plan, and then both of you can say, in 5 years, or they're now in kindergarten, or now they're in high school, or my hours of work have changed. Let's revisit this agreement and see if it works.
But it's very rare that someone would get, I'm going to phrase this correctly here, they would get full custody and full parenting, like full decisions on parenting time, unless there was like an extenuating circumstance. Like, do you see people ask for that a lot?
I do. And I think what can be very tough is...
Don't you think that's a little ambitious? Like why would even their lawyers, you know what I mean? Like if somebody came to you...
To have sole decision making. Well, it's tough. I've got there's situations where... I think that the person in the household who's always taking the initiative to take the child and book their medical appointments, register them for school, always make those day-to-day decisions, oftentimes they think, well, obviously I'm going to be the sole decision maker because I've historically done that. And so I think it makes sense why someone would think that in that scenario based on that status quo. But unless, a court's not necessarily going to rely on that in and of itself to say that you have sole decision making. And so I think people get frustrated that way because they'll say, I've spent the last 12 years doing all of it. Now you're piping up and saying, I want to be part of this process. But unless you can prove that, that person is going to undermine and they're not capable, or they're just going to be combative and you're never going to make a decision. It's almost like the absence of bad decisions kind of presumes at times
because everybody has their own roles, right? Well, they're together, right? Like you're right. Someone might pay the bill, someone might do the dentist appointment, right? Someone might do the sports, so that's interesting. So it's not, it might be assumed because you do it, but it might not necessarily be assumed by the time you do your separation.
Yeah. Or at the time that a judge is reviewing things. And so a parenting plan, especially if a child is younger, courts look to social science research that has been pulled together by child psychiatrists, psychologists that say when a child's super young, it's so important for them to bond with both parents, and recognizing that a whole week away from a dad or a mom or whoever the caregiver is a long time.
Yeah.
And so if you're an active parent and you're going to get 50-50 parenting time, that especially if your child is very young and a toddler, it could be a 2-2-3 schedule, 2-day mom, 2-day dad, 3-day alternating. But then based on their stage in development and their disposition, if they can handle through an acclimated change to their schedule, a turn to 50, like 1 week dad, 1 week mom, and maybe a visit on Wednesday. So the court really looks at what is in the best interest of the child. Both parents may come at it as, this is my right, and often parents do, but the court says, I'm concerned about this child. It is their best interest that is going to trump everything. Can you be there, when they're there to get off the bus? It's okay if you need before and after school care, but if you're never home to see them and you're always deferring to third parties and you can't even put them to bed, then I know you love your child, but the preference would be to be for them to spend more time with a parent. So sometimes it's the best interest test takes into consideration their stage in development, right? Like I was suggesting in terms of when you're 12, your views and preferences can impact this. If you're really young, a long period away from one parent is not going to be acceptable. So, they consider the stage of development. They consider your work schedule. They consider how close you are to their school. Really, the focus is consistency for the child, not trying to completely upheave, their life completely.
And it may be determined too. Okay, for us to get an agreement, you've got to live close. You've got to be within a certain kilometer range. You got to have a 3-bedroom house or whatever it is, right?
Yeah.
And I think it's important too, for parents out there dealing with that. If you had it's like mom's turn and it's dad's birthday or you know what I mean? There's it's my time. Sorry.
Well, usually we include in
Christmas.
Parenting plans can be very exhausting to do because you're probably going over that plan sometimes 50 times for the most minor thing.
Tuesday from 9 to 12, and then I get them from 1 to 5.
Well, that's just it. Is we have generally a regular parenting plan, which is your Monday to Sunday.
Yeah.
And then the holiday plan, which would consider, are you alternating long weekends in the summer?
Yeah.
Are you pausing your regular alternating schedule to say when it's Mother's Day, even though that was supposed to be dad's parenting weekend, that's suspended temporarily on that day to allow for mom to have, Mother's Day and vice versa.
But I'd imagine there'd be people out there that would be like, no way.
I find the Mother's Day, Father's Day thing doesn't seem to be a hill people die on, but it can be hard in terms of Christmas. Christmas is one of the most difficult ones, right?
Well, everybody's
and it depends when everyone,
and
when everyone celebrates. There's some people who Christmas Eve is the more important night, and so sometimes people are reasonable and say, hey, I know that this is your family tradition. Mine's on Saturday, so I'll, do it on Saturday, but
okay, so how about...
That can be tough.
Okay, so how about support? So if one spouse isn't working, okay, and then the other spouse is the proverbial breadwinner, right? There's there's support, right? Or they could ask for support.
Yeah, so there's 2 grounds to ask for support. So you can prove that you're entitled to support on what's called compensatory grounds, which is really saying you gave up an opportunity for a career advancement for the sake of taking a more traditional domestic role in the home.
Yeah.
And so you don't have the skill sets or earning opportunity the same. And so that was accepted. That was something that you agreed to throughout your marriage. And so clearly there's a disparity in your income now and the quality of life you're going to have. And so spousal support is really intended to equalize the playing field. If you're accustomed to a certain quality of life, spousal support is intended to not necessarily make it as equal as it used to be, but to really rebalance the imbalance of the loss of that.
There's a bit of a disadvantage.
That disadvantage. But then there's also the grounds, which are, let's say you did work, but your spouse just earned significantly double, the income that you did. You didn't, lose on earning opportunity. You didn't assume more domestic roles to your expense, but it's just a simple, you earn more than me, and as a result, I'm now going to be disadvantaged once we separate, and that's also a basis to ask for spousal support.
So then, and then of course there's child support as well. You could have like 50-50 split on any bills, but then, or you could just have a straight one party pays the other.
So child support is the right of the child, which means that you can't contract out of that. You can't say, well, I'm just going to send you X amount each month arbitrarily, and you list the receipts. I want to see proof that this is what you said. That's not how this works.
Because you'll get that a lot, right? They she's just spending, or he's just spending.
People all the time will say, I'm paying for this person's car hair, or nails or hair, or just be really aggressive that way. And maybe to an extent, but the reality is kids cost a lot of money, even if that's now my water bills are higher, right? Yeah. So child support is determined based on two things. So how much time does that child spend with a parent? If it's 100% of the time, meaning the other parent has them 39% of the time or less, then the secondary parent is paying the primary parent full child support, 100% of what they're required to pay. And the quantum is based on the number of children and their income. Okay. And so the easiest way to determine their income is looking at their line 1,500 income on their income tax returns. Yeah. You cross-reference that number against the child support guidelines. It's literally a chart. Yep. It's available online. And the number of children. And let's say it's $600. Then that's what is paid to the primary parent who has the kids the majority of the time on a monthly basis. Yeah. That's child support. If the parties share the children 50-50, then both of them owe child support to one another. And you go through the same exercise of, what do you earn? How many children do you have? This is what I pay. And so what can happen is the person who earns more, right, is going to, let's say, pay $600 in child support. The other party is supposed to pay $400. You just set off the net, and one party pays the $200. But that doesn't cover what are called special and extraordinary expenses, Section 7 expenses. These are, child support's meant to pay for the daily things, right? But Section 7 would be the cost of extracurriculars, therapy, sports, day camps, daycare, if any balance owing that's in excess of your healthcare benefits for medical things like dental or orthodontist. So those are separate from your monthly child support obligations, and both parties need to consult with one another and agree to them in advance without being unreasonable. Everyone wants their kids in high-end sports.
This is exhausting.
Everyone loves it. But, one parent who, wants their kid to play hockey, the other parent may say, hey, I would love that, but I can't afford $5,000 in hockey fees a year. Could we do another extracurricular, or there could be an agreement I can afford it. I'll just do it. Yeah. Okay. And your contribution to those Section 7 expenses, particularly if you have a disparity in your incomes, is going to be proportionate to your income. So if you earn significantly more than the other, maybe your contribution to that expense is 70%, and you're asking for repayment 30%. Of 30% from the other spouse.
So So that's child support seems pretty cut and dry in that respect, and then you split whatever the determination of income is, you could split or agree to pay for sports, braces, extracurricular. But spousal support, okay, and just to go back to that quickly, is there a timeline on that, or is there like how long? If somebody's been a stay-at-home mom or a stay-at-home dad for 5 years
Yeah.
and they're 30 years old, but they're still capable of working till they're 50 years old.
Really good
Would
points.
somebody have to pay it? Or like if
Yeah.
they're 45 or 50,
Yeah.
but then the kids have been gone for a couple years, like
Yeah.
do I still pay like for her, like, or his, I
All
say her
those-
because I'm a guy, but
Yeah, all of those factors that you raise are considerations. Absolutely. Like if you've had a very short marriage and you're capable of earning money, right? And you're also sharing in your assets, right, through that equalization process. A judge will consider what was your like starting point when you got married versus now, and take like a holistic approach to looking at like everything to determine spousal support.
yeah.
But if you've been married 35, 40 years and you, for example, a year before you separate, your spouse becomes ill and can no longer work, the court's going to look at the amount of spousal support you should pay that person, not based on their history of employment, but as your spouse was as of the date of separation. Because they recognize that you had a duty and you are here, well, not you are here, but spousal support is really meant to rebalance disadvantage
Yeah.
in income sources and people's ability to meet, a certain quality of life.
Yeah.
And so even if the children have left, spousal support isn't in that circumstance going to take that into consideration. It's you've been married for a long period of time. The longer you're married, the greater chance you're going to owe spousal support if your incomes are very different.
So we've had clients where the wife was a stay-at-home mom, but the two kids have left. Like, they have the kids when they're 21 years old, but the kids are out of the house by they're 40. But then the wife still doesn't work until she for another 20 years, right? Let's say 15, 55, 60. Now, his idea was that he didn't want his wife to work, right? Like that was a class thing, and so when they determined, when they looked at that, she had full support for a particular period of time. I don't know what it was. They split the assets, but like the way I looked at that was that he kind of hindered her ability to start a career even after the kids left.
Well, it was both of their choices, right? And so everyone makes.
But like, would that matter? Like, even let's say I'm like, geez, get a job already. It's been 15 years and you haven't got a job. Like, would that factor in or no? It wouldn't.
You're still going to have to pay spousal support. There's a massive income disparity.
How do I get
there.
around it? I'm just kidding.
Look, if someone intentionally loses their job and creates a situation where they're underemployed,
Yeah.
so that would maybe arise where you've been employed for years and
self-employed.
suddenly you lost your job to defeat having to pay child support or spousal support. The court is attuned to that. People have for many
do that on
years
purpose.
lost their job and started working under the table so that they don't have to pay child support or spousal support. So
Yeah.
there's definitely ways in which a court can look to, okay, well, you say you have no money, but you've got a Maserati,
Yeah.
you've got $1 million home. I don't care what you've declared on with the CRA.
Right.
Just because they'll allow these business deductions doesn't necessarily mean that we're going to allow those deductions. So as much as my simple answer with respect to spousal support and child support is you're looking at your line 1,500 income, there are exceptions, right? Especially if there's self-employment issues, especially if someone has suddenly lost their job.
Would there be a timeline on it? Like if someone got separated and they're 30 or divorced, they're 30 years old. And they're capable, but they've having kids in their early 20s, and the kids are 8, 9, 10. Like, would there be I guess there's a case to be made that they're the stay-at-home spouse, but would there be anything in there that would say we'll do support till this person is 40?
Absolutely. I'm so glad you brought that up, because and the hard thing is there's not like this magic equation that the courts come to this
For spousal support.
Unlike
Unlike child support.
But the spouse that's in receipt of spousal support still has the obligation to become financially independent on their own. And so it's a weird exercise, right?
That's important to know.
So
though.
you look at how long the marriage was, maybe their age, their employability, what skill sets they have. So taking all that into consideration. So sometimes spousal support, particularly if it's a marriage of like 15 years or longer, the courts will say you pay this quantum indefinitely. Now, there's an option if you're retired or you're suddenly unable to pay support, you can make a motion to court to say my spousal support needs to cease and end, and here's the reasons why. But if it's a shorter marriage and you are younger, you are, employable, you have a skill set, the court may say, look, based on the asset division, based on the spousal support you're given, we would expect that in 5 years you have a job, right? But spousal support can be paid and is often paid even when someone doesn't have a job, right?
Yeah.
Or does have a job. So in the circumstance where no one, like a person has never worked, then the expectation is you're going to earn at the very least whatever the equivalent of a salary would be if you're earning,
case.
minimum wage, full-time employment, whatever that salary is. But if you have in fact worked in the past, and earned a certain amount, then the court's going to say, hey, I've seen that you could earn $90,000. Why aren't you availing yourself to those opportunities now? And so there have been instances where, with respect to child support, some people have the room to argue that the income they're declaring is either inaccurate, doesn't reflect, their actual lifestyle and they're hiding money, or they're intentionally underemployed because for 20 years they earned $120,000. Now the past 5 years they're earning $30,000. So a court would say we're going to do what's called imputing income onto you and say you should be earning X amount. And so for the purposes of calculating child support, we're going to indicate that this, in fact, is your income.
And I think being fair is probably one of the most important things that's really happening here, right?
It's tough. There's often times where I don't actually see every outcome as being fair. And I don't think that the law and its process is always fair, but I think that the intent is to balance inequities, at least in family law.
So we've got 5 minutes left, okay? And I got to get this, okay?
Okay.
All right. There's 2 questions here, okay? And you have to be quick.
Okay.
All right. If I'm a stay-at-home dad, my wife is the breadwinner. Mm-hmm. We get a separation. Mm-hmm. She cuts off all funding to me. I have no way to pay for myself or anything like that. How can I mitigate that in a timely manner?
So you can seek an urgent case conference or an urgent motion in court asking for spousal support. And or if you're the one who's primary caregiver and you're in the house and the other spouse is fighting for the house or doesn't want to leave and it's not safe, you can definitely pursue a motion to court to say, I need this housing, right? Otherwise I'm going to be homeless. It depends if you meet the urgency status, but really, I would say
I don't have money for food for the kids.
Yeah. So you're going to probably be several months because you fought, well, maybe not several, but
even a month.
So you file your application to court,
like an
and at the same time you can file a motion. Is that an emergency
injunction?
A motion is almost like an emergency injunction. Yeah, it's not the same, but it's essentially saying, I need this immediately to cure this, right? And so I would say you could, in the best of circumstances, you could probably be heard in a month to get some spousal support or security to remain in the house and or you can ask that your other spouse pay your legal fees to allow you to participate if you haven't been able to qualify for legal aid.
That's scary.
It could be, it could be 3 weeks maybe, but probably not.
3 weeks, like even 3 weeks, right? Like,
yeah.
Wow. Okay. Yeah. I could go on forever. Like, I could talk to you for another hour.
Just because there's so many circumstances you can come up with.
No, I'm going to have you back on. So, like, okay. And then I guess just, I really wanted to go through, like, one of the most heart-wrenching things, and then I wanted some advice, but I'd rather just do, like, can you go through one of the most, like, heart-wrenching things?
I don't know. I think it doesn't sound very heart-wrenching, but it's really painful when you see a really good parent just be given a small amount of parenting time to their ex, who's an involved father or mother, and them wait 8 months to a year to actually have, 50% parenting time with their child, and lose just, especially when they're young, like the opportunity to have those moments to see them walk or crawl for the first time. So I think that's pretty heart-wrenching when someone is a really good parent and their child hasn't been withheld from them completely, like they've seen them, but the court still hasn't ordered yet that they could have more time with them. I think that's really devastating.
And the system kind of works against them, so to speak, I guess, right?
Yeah. Or a situation where there's intimate partner violence, and included in that is financial abuse, where a party has sold a house, has said, we're moving in together, we're getting married, and they pay like $500,000 towards the house, and that was pre-owned, and there's still maybe a mortgage, but they've really thrown all their money into a relationship, and then they're unlawfully ousted from the home with the spouse, locking the doors, locking everything in there, effectively rendering them homeless immediately. And then all the money that they just spent, let's say they've only been married 2 years, in that circumstance, it does, based on the facts of that situation where there's coercive control, physical and sexual violence, and basically kind of a scenario where a person feels trapped and they don't realize they're trapped until all that money's been put in. It's really devastating to see them really not have the means to live their basic life and have the mental and emotional and financial fortitude to then hold that person to account. Yeah. They will, and there will be an avenue to do that, but getting there
takes time.
Is really difficult. Really difficult. Yeah.
All right. Well, listen, it's been a pleasure chatting with you. So for everybody out there, just give them your first and last name again. Give them where you work. Mm-hmm. And maybe I guess if anybody's out there that's struggling, it all starts with a conversation, right? So how would they get a hold of you?
So you would contact my office, Sorbera Law, at 519-836-1510, and that's the office here in Guelph. Yeah. We also have an office in Kitchener-Waterloo, so you can look that office up if that's somewhere that's geographically closer to you. And just give us a call. You don't have to get into every nitty-gritty detail of what's happened, but you can say, I need advice on my separation, or I think I'm going to separate, or I want to talk about what my rights are. I will set up a call. We'll meet in person, or if you want to do it by Zoom. A lot of people don't have the time to leave their home and come to an office. So I love Zoom now. People Zoom me from their cars because they don't want their spouse to know that they're getting this consultation. So, we can set up a meeting, we can discuss things. I tend to give people like free legal information or advice on their first call, and then thereafter talk about, do they still want more advice? If so, I'll say, I'm going to have to bill you by the hour now, or we can look at how do we structure a retainer that really starts our relationship where I'm your representative or agent to help you through this process. But it's not as if the moment you call, there's this binding obligation, right? That you're suddenly required to retain that lawyer as your counsel. So I want to just encourage people to even contact any lawyer that they feel comfortable with. Hopefully it's our firm. I know, we've had a great reputation for years, and I know all of our family lawyers have really great bedside manners and care about the people they're representing. So hopefully you have, a sensitive and thoughtful experience in getting that advice, because it is a difficult time in your life. But yeah, it's really good to even shop around. I'll say to my clients, you've met me, we've talked about this. You have no obligation to sign a retainer now, but if you're worried about my advice or the rapport that we have, go speak with another lawyer and see if they're a better fit for you. But I do find that usually they come back and are satisfied with our rapport. So yeah, you just pick up the phone and call, and you can have a very simple meeting, and we can structure the meeting or the time however you want and really personalize your experience.
Yeah, Sorbera Law, they're the ones, they always have the nice house. It's their office. I mean, it's just phenomenal. It's absolutely beautiful.
I love that office. We've since moved
I
now.
know.
So yeah, the outside of our office looks not as homey, and estate-like, but it's very fresh, and we're happy to have the space now in our just down the street from our office on Woolwich.
Awesome.
Yeah.
All right, guys. Stephanie Cox, everybody. Thank you very much. It's been
you.
great. And like I said, I could talk for hours.
Yeah.
And we'll do this again.
Thank you so much.
Thank you.